So here we are around our Fireside today. I'm Elizabeth Weeks. I'm a partner in the Dispute Resolution Department at Rosenblatt, and I'm joined by my colleague Jacques Domican-Bird, who is a solicitor in the Dispute Resolution team. Rosenblatt is a mid-sized city boutique dispute resolution firm with our sister brand Memory Crystal, combined with Memory Crystal, a full-service law firm. They're specialising in corporate employment, real estate, tax, and all of those other usual areas that you would expect. And we are joined today by Jacob Turner, who is a barrister at Fountain Court Chambers in London. He's recently been named as a global market leader in AI by Chambers and Partners. A former solicitor advocate, Jacob was called to the bar in 2016 and has been with Fountain Court, I believe, since 2018. He's written a number of articles and has been a lead and a co-author of books on AI, delivers a webinar series on ChatGPT and generative AI, and also advises the UK government's Office for AI on a variety of legal and policy issues, as well as advocating on behalf of the appellant in a recently decided first of its kind AI Supreme Court case. And we're delighted to discuss this and much more on the subject of AI, really the buzz topic of the moment. So Jacob, thank you very much for joining Jacques and I this morning.
Thank you, it's a pleasure to be with you.
Fantastic.
Well, Jacob, following that illustrious introduction, I wondered if you'd just pick up a bit more about your background in AI, what sort of gets you going about it, and perhaps sort of what else you've done in the space that we haven't already touched on.
I originally became interested in AI in around about 2015. I was working as a judicial assistant at the Supreme Court, and the judge for whom I was working was asked to give a speech on the future of law. We decided together to write it on law and AI, and it occurred to me when I was researching that speech that almost nothing had been written on it at the time. And I thought there was a real disparity between the increasing importance of AI in the economy and in wider society and the lack of discussion of the problems it could cause, of how we might deal with those problems from a legal, ethical and possibly political perspective. And that's what gave me the idea of writing a book on the topic, which I did over the next couple of years. It was eventually published in 2018. And since then, I've been advising governments, regulators and private sector organisations around the world on different topics relating to AI. And in addition, as Liz mentioned, I've also acted in some of the first pieces of litigation on this topic. I would say at the moment, the majority of the market interest and the legal action in this area is in an advisory and regulatory space. There is, as I'm sure we'll explore, some discussion of the intellectual property aspects, and
Absolutely.
Those are coming to the courts.
Absolutely.
But the rest of the work at the moment is predominantly regulatory and compliance based.
I would absolutely agree, and equally we are all general dispute resolution practitioners, obviously Jacques and myself on the solicitor side, Jacob, you as a barrister, as an advocate, but particularly we are finding it's about early issue spotting for clients in that advisory piece. Largely as solicitors, as members of the legal practitioner community, we are risk managers, and so it's about that early advisory piece, issue spotting. And then I equally agree with you that I think in terms of the decided case law or the actual cases on this area at the moment, it's largely been with that IP focus, as perhaps one would expect, and we'll go on to discuss.
Yes, and I think there is a significant role for litigators to play, as you say, in assisting clients avoiding litigation, but
Yes.
also putting themselves into as good a position as they can be if and when the litigation comes. And certain clients, we know, are at higher risk than others due to their public profile, due to their size or scale. And I've certainly had experience of working with clients on the advisory side, which has then turned into a litigation or a contentious regulatory matter. And the fact that litigators have been involved from an early stage has, I think, been helpful to the clients, because they will have seen what's coming in advance and they will have done what they can to protect themselves.
Absolutely, and I think equally, as we'll go on to discuss, I think a lot of it is just about verification tools and that advisory piece, and actually thinking about how clients and us indeed as practitioners can adopt and use this technology, given it's here anyway, in a safe and productive manner.
So Jacob, thank you for that introductory section, and we'd now like to move on to talk about the UK Judiciary, and first of all the case that you were advocating in the Supreme Court last year, and it is of course the Thaler and Comptroller General of Patents, Designs and Trademarks case, the hearing taking place of March in 2023, and we had the judgment just before Christmas. So just a little bit about the background to the case. It was a 5-judge panel, the judgment written unanimously by Lord Kitchen, and they rejected Thaler's appeal to list Dabus, which is an AI program, as the inventor, in line with the Patents Act 1977. Lord Kitchen said that Dabus was not a person, let alone a natural person, as per the Act, that Dabus was not an inventor, therefore that Thaler could not register Dabus as the inventor, and as such the officer who withdrew the application in the first place was perfectly correct to do so. It was a fairly short judgment, fairly confined to the Act itself, as you may expect, and I think the only real kind of indication as to future direction was a line right at the start to say that it was one of a number of test cases and that it raises issues of some importance. So I suppose, Jacob, as the man on the ground in that hearing, what else is there to say? Was there anything that we can sort of publicly discuss that was interesting from the hearing?
One of the lines of argument which we put forward to the court was the suggestion that even though a statute doesn't expressly say something on its face, there is the possibility within common law rules of statutory interpretation for judges to treat statutes as living instruments, to say not just what do the words say, but what would Parliament at the time have intended the words to say, had they been aware of the relevant fact pattern. Now, that is to some degree a bit of a Hail Mary type argument when you know that the words don't support you, and we were always up against that in the case. So it was always going to be a struggle to say that an act enacted in 1977 could realistically have contemplated the types of generative AI which were at issue
Sure.
in the case. So that was something which we put forward. It wasn't an argument that was taken up by the court, but it is something which has seen some success, including in the Supreme Court in recent years. Mm-hmm. There was a case involving human fertilisation and embryology, in which the possibility of a new type of fertilisation of an embryo that hadn't been contemplated at the time of the Act had eventuated, and the court said that this would have been within the contemplation of Parliament at the time. So we thought it was worth a try.
Not too much of a stretch.
Indeed. But I think ultimately what that series of cases was intended to do was two things. Firstly, to test whether existing law was capable of dealing with this novel scenario of AI genuinely being able to devise new inventions, which it is in many fields. And secondly, if the answer to that was no, to prompt legislatures and governments around the world to consider reforming the law. So I'd suggest that even though we lost, the court did acknowledge the fact that movements in this technology might call for a reconsideration of the general principles, albeit that is, of course, outside of the remit of the courts, and that is a matter for Parliament to take forward if it chooses to do so.
Of course, but obviously the judiciary is an independent function as an independent sort of rule of law. It's very important that these discussions and debates are being had, and as you say, it can sort of prompt regulatory or the need for regulatory change, which perhaps we'll go on and talk about a little bit further. So thank you for that. So moving away from that case, and obviously your involvement in that case, into the judiciary more as a whole, I noted in December 2023, Sir Geoffrey Voss, as Master of the Rolls, issued some AI guidance for UK judicial office holders. And that, as part of his guidance, included key risks which may be encountered and suggestions for minimising those. So again, a sort of risk-based approach. And those risks, as perhaps you might expect, included understanding AI and its applications, perhaps foreseeable issues such as confidentiality and privacy, accountability and accuracy, that verification piece that, again, we'll probably speak a little bit more about today, bias and security concerns. And he followed that up with a speech actually more recently on the 11th of March of this year called AI Transforming the Work of Lawyers and Judges. So this is where we may come in which he proposed that a balanced approach to adopting AI be encouraged. And he noted we can and should make appropriate rules and regulations, but we will not be able to stop something that has beneficial uses for our society. So I think you sort of picked up on some of those in your webinar review of the legal and ethical issues involved in AI. So just sort of wanting your comment really as to what Sir Geoffrey Voss there has alluded to.
With respect to the adoption of AI in the legal field, as indeed in any other field of work which is regulated, I think there are three elements that one needs to be mindful of, and the Master of the Rolls has picked up on all three of these elements. The first is technological capability, so the extent to which the technology can actually do what we wish it to do on a sufficiently reliable and robust basis. And with respect to many functions in the legal industry, I think the technology can now do that.
Yeah.
Not perhaps as accurately or as reliably as we might wish for it to do, and that we're all aware of the situations where lawyers have cited non-existent case law.
Yes, and I think yes, a useful lesson, but yeah,
Indeed.
It provides a useful jumping off point, perhaps, is what you're saying.
Exactly, and for certain tasks, for example, the summarisation of large amounts of documentary evidence, that sort of thing, that can certainly now be achieved on a demonstrably accurate basis by AI systems. But that's only the first part. The second part is cultural uptake. And this is something which is harder to measure, but nonetheless presents a significant barrier to the use of AI. There will, for example, be many cases where technology-assisted review could be used, and indeed it is mandated to be used in the CPR in commercial contexts. And yet, because partners at law firms or clients might not be used to the technology, they might not think of doing so, they might be disinclined to do so, and so that could be a barrier in and of itself. The third and final potential barrier is from a regulatory perspective. There may be requirements, for example, in terms of signing statements of truth or other aspects of the CPR, which prevent or inhibit the use of AI, and that may not be a bad thing at all. We certainly would want, I think, at this stage, for individual lawyers and indeed individual clients to have to take responsibility for what is said on their behalf.
That final sign-off piece.
Exactly. But that said, I think there certainly are reforms that could be undertaken and could be explored, as the Master of the Rolls suggests, in order to facilitate the safe uptake of AI, which may have many benefits in terms of saving money for clients and perhaps ultimately increasing access to justice for those for whom otherwise litigation would be prohibitively expensive or risky.
And I think that's a particular consideration now, where really largely the first port of call in terms of advising a client on a potentially contentious matter, or indeed if you're already in one, is how to manage the data set. Because that's really what it's all about. That's going to the analysis and the analysis and the review of that data set in a cost and time efficient manner is going to be able to advise your client on the merits of any possible action or proceedings that they may wish to take, or that they might find themselves being pursued against by a counterparty. And then equally, if proceedings are underway, how you best manage that data set to inform case strategy and how the proceedings end. So that's what certainly we're seeing. doing as practitioners and the adoption of that AI on disclosure review platforms in any event, I think. It's interesting, it's just leading on from that, and again, as practitioners, Jacques and I have attended various sort of roundtables and discussion groups in the area of AI, and there is definitely interest, I think, to what extent the judiciary itself could make use of AI or large language models. I attended a seminar actually in which there was a member of the judiciary, and she gave her view that actually the preparation of those introductory paragraphs of a judgment, which are in the main, obviously, as we know, taken from party skeleton arguments or opening submissions, actually her writing those out, she explained, is her sort of segue into then the analysis parts of the judgment. And she sort of said that sort of facilitated that subsequent analysis. So thinking about the devolvement of those, the preparation of those paragraphs to technology would be, from her view, undesirable. And so, I think the court's published guidance for judicial office holders, as I've mentioned, on AI, and raising those sort of valid cautionary notes about those issues. So to what extent, that we've already not mentioned, do you ever see, Jacob, in your role as a barrister, as an advocate, do you ever see the judiciary making use of AI as part of the job function or decision making? I suppose it might touch on what you've already mentioned about doing that in a safe, verified way.
I'm certainly aware of situations where judges have admitted that they have used AI tools in order to assist with the preparation of certain parts of their judgments. I haven't been involved personally in a case where that has happened.
Yes.
But what I think is happening in terms of judicial involvement with AI is on two sides. Firstly, there is the potential use of AI as a tool for judges, which I think it's fair to say is not very widespread for all of the sorts of reasons that I mentioned earlier. In terms of, exactly, cultural reasons, technological reasons, and potentially concerns about the propriety of doing so. There will be a minority of judges who are doing that, and that minority will increase as the technology becomes more widely adopted. But the other side of things is where judges are now increasingly being required to engage with AI as part of one of the tools that the litigants are using, and to reach judgments as to whether those tools have been properly used and what tests ought to be applied to verify those tools. So taking AI in disclosure, it has been judicially accepted since the Pirot case several years ago that is something which is permissible and indeed desirable in many cases. But the technology that was being discussed in the Pirot case would have been traditional automated logic-based technology, where there was a series of instructions that were given to a program, and the program simply executed those instructions. That's not the way that machine learning works, where, as you know, it derives its own inferences from a data set and teaches itself its own rules. And we're yet to see a judgment engaging with the way in which data and output produced by AI systems in the true sense of the word functions. And so that is something which I think judges will increasingly need to engage with. And I certainly have seen court cases in which this has been an issue, whether it's in terms of disclosure or indeed in slightly more advanced functions like using an AI program to produce the evidence that one side relies upon.
Yeah, absolutely. And I suppose that's only going to continue as the technology moves with that certain momentum forward. Absolutely.
Everything that we see that our clients are doing in terms of using AI to drive business processes and to create efficiencies and to achieve insights that wouldn't have been possible simply by having humans looking at a data set, those clients are then going to be expecting their lawyers, understandably, to be using those same sorts of tools in advocating for their positions. And so I think it is inevitable that there will be market forces, as well as efficiency-based ones, that push forward the use of this technology. The big question is how judges are going to deal with it, and for the most part, that is as yet undetermined.
Absolutely, but they're going to have to. I think that's clear, given they're going to be adjudicating upon those issues that clients have faced, and then obviously us as professional clients of, barristers' chambers, and then we're before judges, we're going to all have to get to grips with those things.
It seems that there needs to be an understanding from the judiciary about the sort of separation from the human and then the the sort of programs themselves, and until that's fully understood and who the responsibility ultimately lies with, maybe that will be the kind of turning point, is when the judiciary sort of fully accept AI sort of more generally.
Yes, but I think
or
it will
uptake. I suppose,
indeed.
that cultural issue.
I think it will depend a lot on the context, on the scenario in which AI is being used, and whether this is deemed to be a sufficiently low-risk scenario, or alternatively a sufficiently reliable type of technology that it is appropriate for the human to be taken out of the loop, and for decisions that the AI has made in and of itself to be relied upon. But this is going to be a moving target, I think, going forward, because the technology will improve. We're miles away from the situation 5 years ago in terms of the advent of generative AI, and in 5 years' time we may be yet further in ways that we can't yet contemplate. So I think this is going to be something that will be an ongoing issue for judges to engage with. But just because it's difficult doesn't mean that that's an excuse for not engaging with them, or for having some kind of a blanket ban on the use of that technology.
Absolutely. We enjoy a challenge.
Great, so that was a really interesting section on the UK judiciary, and now we're going to turn to talk about the government in the UK. We'd like to start by talking about the Bletchley Summit, the government's AI sort of safety and security summit in early November of 2023. I think by all accounts it was a very successful and kind of well-regarded sort of piece of statecraft for the UK. It potentially shows the UK to be a future leader in the area of AI, and sort of the themes that were discussed at the conference. I think most memorably from the conference, Prime Minister Rishi Sunak came out with the line that he was in no rush to regulate, indeed that the UK government was in no rush to regulate. And that seems to be a position that's held quite firmly until very recently. In only an article only this week in Bloomberg, reports have come out from the Department for Science, Innovation and Technology that draft AI laws are being considered and worked on by officials in relation to closing copyright loopholes. So, Jacob, I suppose, thinking back to Bletchley, no rush to regulate, and then reports now of potential regulations. What can you tell us about your insights into the government's latest thinking on this?
I think it's fair to say that there has been a shift, not just in the UK, but also globally over the last year or so, perhaps 18 months, in terms of thinking around what might need to be done with respect to AI. The advent of generative AI technology, large language models, in particular precipitated by ChatGPT, although there are now many competitors to that technology, the ability of individuals to utilise and to engage with that technology, and the sheer power of that technology, have continued trends that I would suggest have been there for a long time, but I think they have supercharged the engagement in and the interest in the technologies. And that, of course, has come to the attention of governments, who I think are rightly concerned around the potential misuse or the potential malfunctioning of this. So the EU has moved forward in terms of creating the AI Act. Other jurisdictions, such as the UK, the US, have been slightly slower in this regard. But I think the general trend, the general direction of movement is in terms of increasing regulation. The UK has been, I think, slightly caricatured as being anti-regulation, or previously was. I don't think that was ever the case. It was just taking a slightly slower approach. And there's nothing wrong with that. With the new technology, you don't want to rush to regulate.
Yeah.
There is always the danger of foreclosing potentially very beneficial developments in technology. There's the famous example of the red flag laws back in the 19th century, which required somebody to walk in front of cars waving a red flag so as to warn pedestrians about them. And obviously that was hugely damaging to the car industry because the cars couldn't travel at anything more than walking pace. And we don't want to have that with AI. So generally speaking, I think governments are looking at what the dangers are going to be, and are also looking at what steps one might take in order to mitigate those dangers whilst still balancing the very many benefits that AI can bring. And the UK falls into the category of governments which are looking very carefully at those sorts of issues.
And I think particularly just picking up on what you were saying there, Jacob, about timescale, perhaps there's just been a need or a desire to take soundings from relevant sectors and from leaders in industry, or, there's an awful lot of know-how in this country, and so just to make sure that a sort of, there's a coordinated approach and soundings are being taken from those influencers and those leaders.
That's right. One of the interesting things about the Bletchley Park Summit was that it was one of the first truly global initiatives with respect to AI. We have seen some other global initiatives, for example, at UNESCO, to some degree in the OECD, although that excludes several key countries, in terms of coming up with proposals and steps to protect against AI harms. And what the UK was, I think, trying to do was to find common ground between all different nations, and it was able to do that with respect to existential risk and to the gravest forms of harm on which everyone can agree. There might be slightly less agreement on what other steps should be taken to make sure that AI is safe, secure, robust and fair, because those are contested norms. But with respect to the gravest risks, those are that's a baseline that is common across the world, even if not everybody agrees how likely those risks are to eventuate.
Exactly.
I mean, Jacob, do you think there's a parallel to make with the sort of start of the internet, however many years ago, and how the internet became global and sort of cross borders? There wasn't really a sort of conference at the beginning of it all to say, how are we going to manage this? How are we, as kind of leading countries around the world, going to regulate it? How's it going to work? Do you think maybe, I don't know, somehow lessons have been learnt from the internet, which has good parts and bad parts, but once it's out of the bottle, it's kind of it's out there? Do you think there's some part of that within the thinking behind Bletchley?
The internet is a very interesting analogy in this regard, because again it is a truly global technology which had and continues to have the capability of shaping all sorts of events in different jurisdictions around the world. And I think you're right to observe that the internet was characterised by a lack of regulation in its first 30 years of existence. And that may not have been a bad thing. Many of the developments in the internet which have been extremely helpful, things like social media, things like the advent of search engines enabling people to find information quickly and cheaply.
It's been transformative in many ways and affects everybody.
Exactly, and had very serious regulation been placed on the internet at an early stage, those things might not have come about. I think, however, that there is another analogy from history which is also helpful and instructive in thinking about AI, and that is the advent of regulation in space. So just after the first satellite was put into space, just after the first human was put into orbit, the US and the USSR, together with other nations, came together in the early 1960s. And despite this being at the height of the Cold War, they agreed the Outer Space Treaty, which set basic boundaries, basic parameters as to what could be done in space. For example, no weapons in orbit, nobody could colonise the moon. And even though this was a baseline, this was something that was to everyone's benefit. And I think that is a good way of thinking about the approach that the UK and other nations are taking with the existential risk arising from AI at present.
And I think that's very interesting there, what you mentioned about that having been agreed in a certain political contemporaneous for then context, and thinking about whether we're going to possibly have a change of UK government itself. Do you see a change of UK government and the approach to AI being regulated? How do you see that playing out? Obviously, in your role as advising the UK government, do you sort of see a different government taking a different stance or a different tack as to AI regulation, or do you largely see it as a continuation of the same path that we're currently on?
It's difficult to speculate on what a new government might do, not least because we don't have the party's manifestos. But I think one can observe at a high level that there is a general political consensus in the UK that AI is a matter of serious concern, that it does lead to novel problems in multiple areas, whether that is in terms of existential risk, whether it's in terms of workers' rights, whether it's in terms of liability for harm, whether it's in terms of copyright and other intellectual property issues. So there are various baskets into which AI problems could fall, and I don't think there is any disagreement across the major parties that these are all issues and that existing laws might not be sufficient to deal with those issues. So in broad terms, I don't see the results of the election, whatever they
being a vast
may be,
departure from
exactly.
Maybe just a change of emphasis on certain
exactly. Different governments may wish to focus initially on particular parts, but as yet, I think we don't have sufficient clarity as to the directions in which different administrations might go in.
I think this is proving to be a very, very useful and fruitful discussion. So look forward to exploration of the further issues in a part 2.